I will now call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores?
Present.
Senator Orenshaw?
Here.
Senator Lang? Senator Nguyen? Here. Senator Hansen? Here. Senator Krasner? Here. Senator Ellison? Chair Scheibel?
And I am here. Please mark Senator Lang absent, excused. Thank you, everybody, for joining us this afternoon for the Senate Judiciary Committee hearing. We have two bills on our agenda, as well as a presentation. The presentation is from the Nevada Gaming Control Board, and then they will present their bill to us, SB 46. So, and then after that, we have another bill on the agenda, but we will start with the Gaming Control Board, and I'll invite you down to the front here to give your presentation first. This table has 3 chairs, but only 2 microphones. So please make sure that you're speaking into one of the microphones for whoever's in the middle. And to state your name and spell it for us every time. Say it every time you begin to speak. The first time, if you can spell it for us too, please. We would appreciate it. And please go ahead with your presentation whenever you're ready. And afterwards, I will open it up for questions from the committee.
Good afternoon, Chair Scheibel, Vice Chair Flores, members of the Senate Committee on Judiciary. My name is Kirk Hendrick, last name Hendrick, H-E-N-D-R-I-C-K, and I'm the chairman of the Nevada Gaming Control Board. With me at the table today is board member Shandini Sindal to my left, and to my far left is Sebastian Ross, the board's senior policy counsel. Also, several board division chiefs are in the Las Vegas hearing rooms via teleconference with us today. It is an honor to be here today to present an overview of the Nevada Gaming Control Board operations. We provided you all with a copy of our most recent Gaming Control Board quarterly report, which we'll use to make our brief presentation this afternoon. The report is also available to the public on the Gaming Control Board's website. I'll start with the board's mission and guiding principles, which are found on pages 1 and 2. This year marks the 70th anniversary of the Nevada Gaming Control Board. Over the past 7 decades, Nevada's regulatory system has been considered the gold standard for gaming regulation. The Gaming Control Board's worldwide reputation is rooted in the philosophy that gaming, when properly regulated, can thrive and be an important contributor to the economic welfare of Nevada. The board's reputation is built upon a foundation of consistent legal, ethical, and fair-minded practices and actions, bolstered through highly rigorous standards for licensing, suitability, and operation. Maintaining the balance between those rigorous standards and sufficient flexibility to permit innovation and expansion is the overarching goal guiding daily operation of the board, as well as consideration of potential changes to regulations and statutes. Next is an overview of the board and the Nevada Gaming Commission on page 3. As I'm sure this committee knows, Nevada has a 2-tiered system for regulating gaming. The Gaming Control Board consists of 3 full-time board members, with the chair also serving as the executive director of the agency. Currently, the board consists of member Sindal, former Judge George Assad, and myself. There are approximately 400 full-time board employees assigned across 6 divisions who collectively serve as Nevada's 24/7 law enforcement and gaming regulatory agency. The Nevada Gaming Commission is a part-time body consisting of 5 commissioners. The commission is led by Chairwoman and former Judge Jennifer Tagliati. Chair Tagliati actually today is presiding over a commission meeting in Boulder City. Along with her are the 4 other commissioners, Rosa Salas-Rainey, former Lieutenant Governor and State Treasurer Brian Krolicki, George Marcantonis, and retired Supreme Court Justice Abby Silver. The commission has final approval over licensing matters, regulations, and disciplinary cases. Regarding potential new regulations or amendments, the board, the gaming industry, and the public can recommend regulatory changes to the commission, and the commission can also initiate its own regulation revisions. For any licensee disciplinary matters that may arise, the board will act in its prosecutorial capacity to bring forth a case, and then the commission will then act in a judicial capacity to determine whether or not discipline should be imposed. A brief overview of the history of gaming regulation in Nevada can be found on pages 6 through 8. On page 9, you will see a visual depiction of the organizational structure of gaming regulation in Nevada. The chart includes the Gaming Policy Committee. The Gaming Policy Committee is a 12-member body that meets at the call of the governor, who chairs the committee to discuss significant matters regarding gaming policy. A list of committee membership is noted on page 7. The committee's gaming recommendations are advisory in nature. However, the committee provides a forum for a wide group of stakeholders to discuss major gaming policy issues. Turning now to the divisions within the board structure, there are 6 divisions spread across 5 statewide locations in Carson City, Las Vegas, Reno, Elko, and Laughlin. A description of the administration division begins on page 10. The administration division supports the other 5 operating divisions with regard to facilities management, contract and purchasing facilitation, accounting, budgeting, and record retention services. Additionally, the board's information security and administrative hearing offices are housed within the administration division. The economic research section is also within the division, and that is the group that is responsible for forecasting gaming tax and fee revenues for the state economic forum as part of the general fund revenue projection. The administration division also provides legal and policy research to the board, the legislature, and the governor's office. Chief of the administration division, who is present in Las Vegas, is Nathan Riggle, and he presides over 7 other professional staff and 17 administrative staff. Next is a description of the audit division. Begins on page 12. The audit division is primarily responsible for auditing Group 1 casinos throughout the state. The definition of a Group 1 casino is based upon a gross gaming revenue threshold adjusted annually in accordance with Consumer Price Index. There are currently 147 Group 1 licensees that gross over approximately $8 million annually. The audit division operates in a 2.5 to 3-year audit cycle. The primary objectives of the audit would be to determine proper reporting of gaming and live entertainment revenue, and whether the casino is compliant with all applicable gaming and live entertainment laws and regulations. Additionally, the audit division periodically performs cash counts to ensure a casino is carrying sufficient funds, analyzes annual financial statements to monitor financial viability, and prepares reports summarizing details of certain transactions such as loans and leases. The chief of the audit division, also present in Las Vegas today, is Rusty LeBlanc, who leads a division of 92 employees. 1/3 of the audit division's professional staff are either certified public accountants or have passed the CPA exam and are in the process of satisfying their experience requirement. On page 15, you will see a description of the enforcement division. The enforcement division operates 24 hours a day, 7 days a week, and is responsible for conducting all criminal and regulatory investigations ranging from simple violations to complex multi-jurisdictional investigations in conjunction with other federal, state, and local law enforcement agencies. The enforcement division also investigates and arbitrates disputes between patrons and licensees. Additionally, the division processes and conducts background investigations of registering of gaming employees who work in the gaming industry in Nevada. The chief of the enforcement division is Christy Torgerson, present in Las Vegas. Chief Torgerson leads 92 sworn peace officers and 28 administrative staff located throughout all 5 offices in the state. Agents of the Game Control Board Enforcement Division are Category 1 post-certified. They carry firearms, they must complete a gaming academy and their field training program. They are also able to conduct covert investigations into criminal activities related to gaming. A description of the Investigations Division begins on page 18. The Investigations Division is responsible for investigating all individuals and corporate entities seeking a privileged gaming license, registration, finding of suitability, or other approval. Applicants for these approvals are subject to extensive investigation of personal background, business history, and financial activity to verify their suitability. Agents further investigate and analyze activities of all privately held business entities seeking a gaming license or registration. These agents produce detailed reports to the board and commission for licensing and approval recommendations and decisions. The chief of the Investigations Division is Carl Hoffman. He's actually in Boulder City today with the commission meeting, and Chief Hoffman, after 32 years, will actually be retiring next month. So we thank him for his service to the state. Investigative agents generally have college degrees in business, finance, criminal justice, or extensive law enforcement and investigative experience. Also, the Corporate Securities Division is housed within the Investigations Division. This section monitors, investigates, and analyzes activities of publicly traded corporations and their subsidiaries involved in Nevada's gaming industry. Any licensee who's traded on a public exchange is subject to review by Corporate Securities Section. This includes review, evaluation, and audit of license compliance plans, handling special projects, monitoring foreign gaming reporting, which includes notices to the Board of Activities of any licensees involved in gaming in other states or around the world. The Investigation Division is also the home to Applicant Services, which takes in all applicants by anyone expecting or anticipating to be involved in Nevada's gaming industry. Additionally, the agency has a liaison who responds to requests for information from governmental agencies around the world, including consistent requests by states and other countries that are either currently regulating gaming or that hope in the future to be regulating gaming. A description of the Tax and License Division begins on page 21. The Tax and License Division oversees Group 2 licensees, which currently consist of 306 locations that have annual gross revenue of approximately $8 million or less. This division also operates in a 2.5 to 3 year audit cycle of those locations. The chief of the Tax and License Division is Chan Linksavath, who is present in Las Vegas with us today. He leads 21 employees in his division. The division consists of 3 sections: the collections section, which is responsible for collecting all deposits and distributing gaming taxes, fees, penalties, interest, and fines to the general fund. The compliance section performs reviews of Group 2 casinos throughout the state and conducts reviews of all manufacturers, distributors, slot route operators, and mobile gaming operators not associated with Group 1 casinos. The licensing section issues all gaming licenses approved by the Commission. Additionally, the section is tasked with maintaining the licensee database, including owners, key employees, and all other license conditions upon those approvals. The division also monitors 2,062 restricted locations throughout the state. A restricted licensee location operates 15 or fewer slot machines at establishments such as bars, taverns, grocery, and convenience stores. The Tax and License Division utilizes various methods in order to gather audit evidence. Covert or surprise observations of casino procedures are routinely conducted on an interim basis throughout the audit period. A description of the Technology Division begins on page 23. The Technology Division is primary point of contact at the board for all new gaming innovation. The chief of the Technology Division is Jim Barbie, also present in Las Vegas with us today. Chief Barbie leads 45 employees. Their fundamental role is to be sure that they review all technology used directly in conducting gaming activities in Nevada's licensees. The division reviews and makes recommendations to the board and commission for new and modified gaming devices and associated equipment. The Technology Division also assists innovators with technology to be sure that the board and commission can provide regulatory and technical support for any new products that are anticipated to be presented to Nevada's customers throughout the state. Additionally, the Technology Division supports the Investigations Division during licensing process and data acquisition. The Technology Division also provides all IT support for the Gaming Control Board. A description of the board's Talent Management Division is on page 25. This is led by Human Resources Manager Tricia Bookhart. Talent Management has 3 professional staff, 5 administrative staff, responsible for recruitment, employee regulations, compensation, compliance, and serve as a liaison for Public Employees Benefits Program and Public Employees Retirement System. The unit also includes board's training section and professional standards. Lastly, I would like to highlight some of the information that begins on page 26. At the close of fiscal year 2024, there were 2,990 gaming licensees in Nevada. Included in that number are 468 non-restricted licensees. As mentioned previously, a non-restricted licensee is granted for an operation of a property of 16 or more slot machines, or a property having any number of slot machines together with any other live game, gaming device, race book or sports pool, a slot machine route, or a mobile gaming system. As mentioned in the Tax and License Division overview, there are 2,062 restricted locations in Nevada, which are those properties with 15 or fewer slot devices. As of June 30th, 2024, there were 131,540 slot devices at non-restricted locations, 19,477 slot devices at restricted locations, and a total of 5,625 table, card, and counter games. The state's gaming revenues are on page 29 for fiscal year 2024. Statewide gaming totaled approximately $15.76 billion. As this committee knows, Nevada's gaming industry and related entertainment industry provide vital revenue to our state. The board and commission serve as the taxing authority on behalf of the state and the gaming industry. For fiscal year 2024, the board collected over $1.23 billion in taxes, fees, and only experienced $1,740 in uncollected revenue. This accounts for a collection rate of 99.99998%, something that the board is very proud of. Chair Scheibel, that concludes the Gaming Control Board's presentation. We thank you for your time. We'd be happy to answer any questions that you or the board members may have before presenting our board bill.
All right, thank you so much. Are there any questions from members of the committee? All right, I don't see any questions. So that will take us to our bill presentation. Give me just one moment to get organized. All right. I was just making sure that we made the amendment available to everybody because the Gaming Control Board themselves did send me a proposed conceptual amendment that I assume you're going to present alongside SB 46 since it does change a couple of different sections. It wouldn't really make sense to do them out of order. So within just a few minutes, you all will be able to see the amendment on the meeting. And I'm sure you've all used Nellis before, but since this is one of our earlier meetings, just to clarify, you have to go to our committee link and then go to this particular meeting, and the amendment will be listed as an exhibit to the meeting. Since it's not a formal amendment, it will not be there if you just navigate to the bill, SB 46. You have to navigate to our meeting today on Thursday, February 27th, go to exhibits, and then you'll see the proposed amendment there within the next few minutes. Sounds like it's up now, but you just might have to refresh your screen. And then with that, I will open up the hearing on SB 46. Please go ahead.
Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the committee. For the record, I am Kirk Hendrick, H-E-N-D-R-I-C-K, Chairman of the Nevada Gaming Control Board. Joining me today at the table, to my left is Board Member Shandini Sindal, and to her left is Sebastian Ross, the board's Senior Policy Counsel. Also appearing today via video conference from Las Vegas are 5 board division chiefs and other staff. First of all, let me say thank you for allowing the board to present its agency overview also with this board bill today at the same time. We appreciate that. We also appreciate the fact that we've submitted a few minor amendment changes, and we will be addressing those today as well. We appreciate your indulgence with that with us, Chair. As mentioned, we are here this afternoon to present Senate Bill 46 along with that proposed amendment. Senate Bill 46 seeks to make minor changes to Chapter 463 of the Nevada Revised Statutes in order to streamline and clarify processes essential for the continued success of Nevada's gaming industry. For reference, when the board submitted its bill draft request for SB 46, the intent was to group together all non-technology related matters into one bill, and a separate gaming related bill, Assembly Bill 58, likewise attempted to group together all technology related gaming matters. With the chair's permission, Mr. Ross and I will address these 10 sections of SB 46 by topic area. The first topic area is Section 1. These amendments clarify how previously granted commission approvals and board registrations can be voluntarily surrendered to the board. The intent of Section 1 is to expressly codify the long-standing practice of the board that the board and commission maintain the ability to pursue disciplinary action and tax collection even if a person, as defined by NRS, wants to surrender a gaming license or if a person leaves their position with a gaming company. Specifically, Section 1 clarifies that persons who have received commission approvals or registrations from the board for either a gaming license, a finding of suitability, a preliminary finding of suitability, or a non-gaming employee board registration are still within the board and commission's jurisdiction if there is an attempted unilateral surrender of a prior approval. Section 1 also clarifies that the Nevada Gaming Commission regulations must establish a manner by which the industry will know how to surrender an approval or registration. Additionally, Section 1 provides that the Commission will need to pass regulations defining the time frame before the board divests jurisdiction following a voluntary surrender of an approval or registration. For the record, registration of gaming employees, as that term is defined at NRS 463.0157, are not impacted by this proposal. Turning to the amendment originally proposed in Section 5, that proposed revision is no longer necessary based on the board's latest amendment that we submitted for Section 1. NRS 463.270 subsection 8 already authorizes the Nevada Gaming Commission to pass regulations regarding voluntary surrender of a license, so that matter would not be changed. Turning to Section 3 of SB 46, the proposal clarifies that investigative hearings may be conducted by one board member or by a hearing examiner authorized by the board chair. This would bring terminology in line with the definition of hearing examiner, which uses the term authorize as opposed to appoint. The proposal also allows one or more board members to conduct an investigative hearing without a concurrence of the majority of the board. The intent is to streamline the administrative function of authorizing a hearing examiner by the board chair, who is executive director of the agency. Section 2 of SB 46 would conform the definition of hearing examiner to clarify that an authorization would come from the chair of the board or commission. And another conforming reference is made in Section 8. Moving to Sections 4 and 9 of SB 46, the board is proposing to repeal NRS 463.169 regarding registration or licensing of a person conducting tournaments or contests in association with a gaming licensee. The board's proposal recognizes that gaming licensees are responsible for their own tournaments. Accordingly, it is not necessary to register a person who conducts a tournament on behalf of or in conjunction with a licensee. However, for the record, the board has no intention to completely relinquish jurisdiction over persons conducting tournaments. Specifically, Section 4 of SB 46 would ensure that a person conducting a tournament may be called forward by the board or the commission for a finding of suitability or licensing, but ultimately, the licensee is responsible for any tournaments that it conducts. To be clear, the proposal does not impact a licensee's own gaming employees. We are speaking about third parties who conduct tournaments. Turning to Section 6 of SB 46, here the board proposes to raise the monetary fine threshold to an amount not to exceed $500,000 for violations which are subject to an initial complaint under NRS 368A, 463, 464, 465, and commission regulations, and an amount not to exceed $1 million for each violation in a subsequent complaint. To be clear for the record, the threshold proposals in Section 6 are not required fine amounts. The Nevada Gaming Commission currently has and will continue to have the entire range starting at no fine whatsoever up to the maximum amount for each violation. And of course, the board, acting in its prosecutorial role, can and always does negotiate with licensees for potential higher or lower fine amounts with commission acceptance regardless of this proposed increase. Additionally, Section 6 removes specified fine amounts for violating regulations adopted pursuant to NRS 463.125. Although the proposed amendment deletes fines associated with violating NRS 463.125, a licensee is still subject to the fine amounts in NRS 463.310. The revision in Section 6 is necessary because the amount referenced a fine that was previously imposed for violations of a repealed Nevada Gaming Commission Regulation 6A. Former Regulation 6A was an exemption from the U.S. Secretary of the Treasury based on Regulation 6A being similar to federal anti-money laundering requirements. The federal government now solely investigates and enforces Federal Bank Secrecy Act violations. Therefore, maintaining a specific fine for that type of violation is no longer necessary. I'd like to now turn the presentation over to Mr. Ross to address Sections 7 and 8 of SB 46.
Thank you, Chairman Hendrick. Good afternoon, members of the committee. For the record, my name is Sebastian Ross, last name R-O-S-S. I'm the Senior Policy Counsel with the Nevada Gaming Control Board. Turning your attention to Section 7 of SB 46, the board proposes administrative cleanup regarding records for judicial review. The amendments provide a feasible time frame for the Nevada Gaming Commission to transmit records to the local district court. Currently, subsection 1 of NRS 463-316 states that the commission must prepare a record on review upon written request and payment of reasonable costs and fees associated by the petitioner. Subsection 3 of the statute, however, says the commission must file the record within 30 days. Consequently, there's an ambiguity regarding what happens if the petitioner does not pay within 30 days. The proposal in Section 7 of SB 46 clarifies the Commission's obligation regarding transmitting the record on review pertaining to a petition for judicial review of a Commission disciplinary decision or a gaming employee registration appeal. Additionally, the amendment addresses that the petitioner's failure to pay the reasonable costs and fees associated with the preparation of the record by the deadline is grounds for dismissal. We believe that these changes will serve as proponents for judicial efficiency. In relation to Section 7, the board submitted an amendment to NRS 463-3664, which would clarify the board's obligations regarding transmitting the record on review to the district court pertaining to a petition for judicial review of a patron dispute. The last topic in SB 46 is Section 8, where the board proposes to raise the monetary threshold for patron dispute claims that are resolved by one of the board's hearing examiners. Raising the threshold in Section 8 would streamline the process for disputes involving less than $1,000. This is up from the $500 that was last set in 1991. To be clear for the record, all decisions by hearing examiners would come only after a patron has an opportunity to exercise their procedural due process rights by presenting their case at an administrative hearing. A patron would have the ability to petition if they were not satisfied with the prior decision of one of the board's enforcement agents following an investigation of the patron's disputed claim. And with that, I want to thank you, Chair Scheibel. This completes the board's presentation of Senate Bill 46, and we'd be happy to answer any questions that the committee may have. Thank you.
Thank you so much. Committee, do you have questions? We'll start with Senator Ellison.
Thank you. I do have a couple questions. And number one, how many complaints or violations do you deal with on a yearly basis? You got any idea?
Kirk Hendrick for the record. Thank you, Senator Ellison. If you're speaking about formal complaints that the board actually files against licensee that would be formally filed disciplinary matters, that is a handful a year, possibly between 5 and 15 that end up being contested disciplinary matters. If you're talking about complaints that get to the enforcement division, hundreds, if not thousands, and appeals, I don't know, Mr. Ross, if you have the number of appeals, do you have an approximation of how many? These would be patron appeals where they come out, a patron says, I don't believe I got properly paid what I was due, either from this gaming device or from my table game, and those, they have a right to appeal. Do you have an approximate number?
Between June 1st of 22 through June 1st of 24, we had around 50 that actually went to the administrative hearing level.
Okay, thank you. Follow up, ma'am? Thank you, Madam Chairman. When I got into when I got into the fines here on section 6, and I started with D, number 1, it says not less than 25,000 jumped up to 250, and then that's been removed. Then you go back down to 2 on line 16, it goes from 100,000 to 500,000. That's still, the 100,000 is released, but the 500,000. But the one that gets me is number 2, not more than 25,000 jumped to 1 million. Why would that be such a large increase? I mean, that's a massive fine.
Kirk Hendrick for the record. Thank you, Senator Ellison. Yes, the fines that you're speaking about, let's take them one at a time. The first one was the one you mentioned that used to say we're asking to have it deleted, 25,000 and not more than 250,000. That's the one I was referencing that had to do with former federal law where the Gaming Control Board and Gaming Commission had an exemption. So in order to match with the federal law, it was a requirement that any fine that we would have imposed had to match with the federal law fines. Now that the federal government is solely investigating and prosecuting Bank Secrecy Act, there's no reason for us to have that fine. However, any violation of a licensee who doesn't follow federal law, for example, is still subject to normal fines under the Gaming Commission. Those have been the other two that you referenced. The current one is a fine of not more than $100,000, which we're asking to have increased to not more than $500,000. And then the second would be one that is not more than $250,000 that we're asking to have it increased to not more than $1 million. And again, as I mentioned during my statement, these can start at 0. And so there is a range for the commission to impose. The last time these were increased was 1977. They actually started in 67 when it was put into statute as $100,000 for the licensee and potentially $50,000 for a person working at the licensee. In 77, the legislature said, let's just make them the same, and they said $100,000 for the first violation, up to $100,000 for the first violation, up to $250,000 for the second violation. We believe that over the last approximately 50 years that these amounts should be increased in order to deter bad action. We're not saying that licensees are doing anything wrong. We hope that they don't. And 99.9% of the time, they're not doing anything wrong. That 0.1% where maybe they are doing something wrong, they generally self-report to the Gaming Control Board. So we want to be sure that there's a deterrent factor in effect, and then if there is any violation, that the commission have a wider range to ask potential fines in place.
And I'm sorry, I didn't hear that first part when you did talk about the federal, but I did catch part of it, and I've got my piece running now. But what would trigger $1 million fine? Is that like hiding money? I mean, how could something get that high? I mean, would it be extortion? Would it be rigging machines, or what would really create that? And I'm just trying to get my mind around $1 million fine.
Thank you, Senator Ellison. Kirk Hendrick for the record. I can give you a little brief history on some of the fines. The largest fine Nevada Gaming Commission has ever passed had to do with Wynn Resorts, the company, and that was a $20 million negotiated fine. That didn't go to a hearing because it was negotiated. The next largest fine that was ever imposed was against Steve Wynn personally, and that was $10 million that he paid. Those matters received a lot of worldwide attention, and part of that is under Regulation 5 of the Nevada Gaming Commission, no licensees may bring disrepute or bad press upon the state of Nevada, the gaming industry. Those instances with Mr. Wynn and his former casino licensees brought obviously some bad press to the state of Nevada. So those are the largest fines. Other fines that may be of the range of $5 million or so were again negotiated. This had to do with a company called Cantor Gaming, and they were accused of potential money laundering, and one employee was actually criminally prosecuted. Other fines are usually in the range of hundreds of thousands of dollars, possibly millions of dollars, for conduct that is way outside the regulations and statutes. Very, very seldom do you see criminal action. If you see criminal action, or if you see anything that has to do with a licensee being involved in just blatantly avoiding Nevada's gaming laws and statutes and regulations, there is a potential to actually take their license away. That's the most significant thing that can ever be done to a licensee, is revoking their license. They would rather pay a fine than lose that license. A privileged license in Nevada is worth an awful lot of money.
All right, I think Vice Chair Flores has a couple of questions. Go ahead.
Thank you, Madam Chair, and thank you for the presentation. And obviously, thank you for always trying to ensure that we uphold that gold standard. I think everybody in this room agrees that that is incredibly important, that we continue to be that and that we cooperate and work together to achieve that agenda. I was going through Section 1, and I'm looking at the amendment. Thank you for that. Can you walk me through, presently, if somebody has the privileged license and they want to surrender the license today, is the board on the hook to have to accept that release of the license, or is there still things the board can do at that point?
Kirk Hendrick for the record. Thank you, Vice Chair Flores. Section 1, the intent here is to codify practice. So specifically answering your question, if somebody right now tried to unilaterally surrender their license, most of the time they do this for just normal reasons. I'm no longer going to be in this position at that casino. I've moved to another casino, or I've left the state. I have another job. Sometimes, very, very seldom, you may have a licensee or somebody found suitable or registered by the commissioner board who says, I may be expecting disciplinary action against me, and I'd like to surrender my license. In those situations, what happens is the Tax and License Division says, we're going to put an administrative hold upon your approval, let's call it, because there's a list of potential approvals, and that is held so that the board can conduct an investigation and possibly present disciplinary action to the Gaming Commission. So right now, the policy would not allow them to do it, but the statute, I will say, may allow some potential for somebody to make that argument, which the board would obviously refute and would take that to the courts if necessary.
Madam Chair, if I may continue. Thank you, Madam Chair. And so I'm trying to think of a hypothetical, and obviously you see many instances, but will we have any circumstances where we'll have the ability to do the administrative hold, as you alluded to now, and then punting it down to the commission to create regs? I'm assuming that what we would see happen is that in the adoption of the regs, we would see this notion of the administrative hold. I'm trying to understand what happens after. So you don't do the administrative hold as intended now. You don't catch the individual who potentially is trying to avoid, to still be under your jurisdiction, is trying to get out of it. The administrative hold is missed. They surrender their license. If we move forward with this, how do we see the commission moving forward there?
Thank you, Senator Flores. Kirk Hendrick for the record. I believe the hypothetical that you put forward is exactly what we're trying to cover by this statute and then future Gaming Commission regulations. However, if somebody were to slip through the cracks, for example, very, very little chance of that happening, because in order to surrender their license, the Tax and License Division actually has an administrative duty to take that license out of the system. So very little chance of that happening, but let's say it did. This statute would allow the commission to pass regulations that says the board has a certain amount of time to investigate that person or that entity before the surrender is effective. And that's what the commission regulations will say.
And Madam Chair, if I may do another follow-up. Thank you, Madam Chair. And I know that having a statute of limitations and addressing that now, we're going to punch it down. I understand that. But have we had conversations what we're looking at here in terms of how long of a timeline are we looking at? So that obviously the intent is not to have somebody in perpetuity to be subjected to be able to come back, right? I understand that as well, but I'm just trying to understand what we're thinking as we're working with different stakeholders.
Thank you, Senator Flores. Kirk Hendrick for the record. Yes, we've had some preliminary discussions with the Nevada Resort Association representatives just about that exact question that you've raised, is how long should somebody who says, I'd like to administratively surrender my license or my approval, my registration, whatever it may be, how long should the board have to conduct an investigation and to initiate disciplinary action? We can't say to complete disciplinary action because that may take months of discovery. It may take commission time. They could actually appeal to the court. So it's the initiation, the investigation period, the initiation period. We haven't come to any final determination, but I would expect that number, just me speaking personally, probably somewhere between 1 and 2 years to give the board time to conduct a thorough investigation and to initiate a disciplinary action.
Thank you, Madam Chair. If I have a couple more questions, but I want to give everybody a chance. If they don't get asked, if I could get a second bite at the apple. Thank you, Madam Chair. And thank you.
Of course. Let's go to Senator Orenshaw next.
Thank you very much, Chair. My question, with the proposed changes to Section 1 and in the amendment, would this continuing jurisdiction only apply to acts of the licensee before they attempted to surrender their license, or do you foresee it continuing to activities post their attempt to surrender their license, Mr. Chair?
Thank you, Senator Orenshaw. Kirk Hendrick for the record. Very fair and reasonable question. We would expect that, and I will put this on the record for me speaking personally. I can't speak for future boards, but I will speak for me personally. Part of the reason we want to put this in regulation is so that questions like that can be defined rather than putting them in statute, because that gets into kind of some nuts and bolts. But I will say for the record, me personally speaking, it needs to be what that person did while they were licensed, approved, registered, found suitable. It wouldn't have to do with something afterwards, because I think the clock starts at the time they try to surrender whatever their approval may be, and it should be for the conduct while they were in that position. Now, if they try to apply for another gaming license or approval in the state of Nevada, everything they do for any future application will be part of their investigative process. But from a disciplinary standpoint, that should be the start of the clock.
Thank you for the clarification, Chair Hendrick. Thank you, Chair Scheibel.
Okay, we'll go next to Senator Wynn.
Thank you. Just to kind of go back to what Senator Flores was asking about the statute of limitations. I understand what you're trying to accomplish with like some of this continuing jurisdiction in Section 1 in particular. It just gives me a lot of concern that there isn't a little bit more guidance in these proposed amendments to guide that statute of limitations. I appreciate that you're having conversations with the resorts and the interested parties in formulating those. But as you know, we don't get any oversight in the regulatory process as we do in other agencies where they come to Legislative Commission for approval of legislative intent. So I'm wondering if you could just expand a little bit more on how you intend on crafting some of these regulations to ensure that we don't have just ongoing statute of limitations where there are no statute of limitations. Are there certain types of violations that you're looking at including in those? I don't know, just if there's any more intention that you could put on the record.
Thank you, Senator Wynn. Kirk Hendrick for the record. Let me start by saying that we don't have a hard number of months or years to put in here. And one of the reasons why we don't is because we might find out that maybe the board doesn't need 2 years. And so by putting it in regulation could bring the time limit down. I don't think anybody's intending to have the time limit go further than 2 years. The time for the board to investigate any disciplinary action and file a disciplinary complaint should be done within a year. I'll say that for the record. It may take a little bit longer, so by having a industry workshop with everybody involved, all stakeholders, it may come out to be 12 months, 18 months, 24 months, somewhere like that. In terms of what regulatory or statutory violations we're talking about anything they may have done that would subject them to discipline. So that is very wide-ranging. Criminal matters are handled by criminal courts. But if a licensee or registrant were to say violate a criminal statute, they would be subject to discipline for their privilege license. I hope that answers your question.
No, it does. And Chair, may I ask one other question regarding some other changes? Thank you. I'm kind of looking at Section 6, some of those changes to the fine. I appreciate, and I'm less concerned with some of the increases, which I think are probably long overdue, since we haven't adjusted them since 1977. But I do have some questions about some of the deleted language in subsection D, subsection 1. As it relates to like the initial like complaint and potentially subsequent complaints around this area. Is it your intention, like let's say like a casino had a complaint for like a minor in a casino, and that was the initial complaint. They paid the fine, and then subsequently they had another violation for a minor in a casino. You know, it's my understanding in the way it's previously in statute is that would be a subsequent complaint. I don't think there's quite as much clarity now with the way it is proposed in the bill today. If you had a situation with that scenario where the first complaint was like a minor in a casino, that would be the first complaint. And let's say you had another complaint at the same casino, but this time it was some sort of accounting problem. Would that be considered another initial complaint, or would that be subsequent for the purposes of this rewritten section of the statute?
Thank you for the question, Senator Wynn. Kirk Hendrick for the record. The section you're talking about, as you noticed, is currently in 463, so we're not changing that language speaking to a initial violation or a subsequent violation, but I can tell you that historically, since that was put into place back in 1967, the commission has always had discretion to determine whether or not it has to be a exact same type of violation or not. Generally, it's not. But again, the fact that the fine range starts at 0 and now currently goes to $100,000, or second violation starts at 0 and goes to $250,000. I just couldn't find anything where that's come up. There was a licensee, I mentioned the Cantor Gaming situation, where there was subsequent complaints filed against them. The cases ended up settling, which 99 out of 100 of these cases with privileged licensees do end up settling. So the commission didn't have to specifically address whether or not they were going for a subsequent violation. Again, if they did, they would have the range. And I will say to Senator Ellison's earlier question, the fine they paid was way above what they had gone and had to pay if the commission found a violation of, let's say it was a subsequent violation of $250,000 cap. They would have only paid $250,000 times each violation. They paid over $5 million in those combined complaints.
Thank you, and thank you, Chair. That's all.
We're going to go back to Vice Chair Flores.
And thank you for that. Thank you, Madam Chair, for the second bite at the apple. Besides taxes, I understand there may be taxes owed, and there's some fines that you may have to implement. Is there any, and this is just me for my own knowledge because I haven't sat down and really dissected disciplinary action. Does it ever go beyond a fine? Is there any other authority that you've implemented on somebody that is not related to some type of monetary fine? And I don't know if you have the authority to do anything beyond that. I understand there's criminal proceedings that would be started. But this is just for my own knowledge to understand it. But before I ask the other question.
Thank you, Vice Chair Flores. Kirk Hendrick for the record. Absolutely. Fines are one way to deter bad activity, but as I mentioned earlier to Senator Ellison, the most significant disciplinary action the Gaming Commission can take against a privileged licensee is to revoke their license. They could suspend that license, and very often do impose conditions on a license. Conditions are things like you must do these things, you must have these type of reporting requirements, you must put in new people, you must have outside accounting firms. Often conditions are added to a disciplinary settlement without even going to a hearing. Most time privileged licensees understand that yes, I will agree to those conditions. The other is very significant, which would be a limitation. Limitation is a word in gaming that means time. So you may say to somebody, you have had a privileged license that in Nevada, our licenses aren't determined by time. Some other states they are. You may get a 5-year license. In Nevada, you get a license in perpetuity as long as you pay your taxes and follow all the rules. If you did something disciplinary-wise, the commission could limit that license and may say, you've only got that license now for 1 more year or 2 more years, and then you've got to reapply.
And I apologize, and it was my fault that I didn't correctly phrase my question. I was more focused on the initial hypothetical where somebody wants to surrender their license. They're going to completely detach themselves from anything gaming, because they're trying to get away from being under your jurisdiction, but at that time, you don't allow them to surrender the license. What I'm curious to know is, in that hypothetical, they're surrendering the license. We know that, unfortunately, they're never going to be able to do that again. They're never going to have that privileged license. In that scenario, will you do anything in addition to going after money? And the reason I'm asking is, the statute of limitations means more if there's other actions you can take, because if all you can do is go after money and they surrender their license, they've completely detached themselves from all money, they've got rid of all their assets, that puts us in an uncomfortable position because 2 years down the road now, they've kind of made themselves judgment proof to an extent. And I'm not suggesting that happened before. It's that easy to do that for somebody of that stature in any position. But I'm just curious to know if there's anything other you can do in that factual pattern where it's been 2 years now down the road, we're still going after this individual, they've kind of strategically moved away from all their assets. What do we do in that scenario?
Thank you, Vice Chair Flores. Kirk Hendrick again for the record. My apologies for not understanding your question. I should have understood where you were going. And to answer your question, yes, 100% the board can negotiate with the licensee, registrant, applicant, person found suitable for things beyond fines. And I can give you a recent example regarding Mr. Steve Wynn. He not only paid a $10 million fine, he agreed by contract, the stipulation being a contract between the board, himself, and the commission as the approving authority. He entered into a contract where he will never again seek to be licensed or found suitable in the state of Nevada. He will not be involved in gaming business in Nevada. So yes, there are conditions, there are contractual stipulated provisions that go way beyond the monetary fine. And this happens not just to speak about Mr. Wynn, other licensees, applicants, registrants would be in the same boat where you must pay us this amount of money, but we are also going to say if you ever come back and seek a licensing, it will be under these conditions, or we may never accept another license from you because you've contractually agreed to it.
Thank you, Madam Chair, for the second bite, and thank you. And again, I didn't phrase my question correctly. My mistake. Thank you.
Yeah, Senator Hansen.
Thanks, Madam Chair. That thing on? Yeah. The Steve Wynn thing you brought up. Now, is he, when you go after somebody as an individual like that, but he's still part of a bigger corporation, like, is his same gaming company still allowed to function in Macaw, for example? Or is there somewhere that you guys kind of pierce that corporate umbrella with an individual like that? Or are you strictly limited to literally the borders of Nevada?
Kirk Hendrick for the record. Thank you for the question, Senator Hansen. Yes, our jurisdiction stops at the borders of Nevada. We have wonderful working relationships with all these other licensing authorities throughout the world. And so if they were to call and ask us for our investigation, what our disciplinary matters resulted in, we would certainly cooperate with them. But yes, we couldn't tell any prior licensee or registrant what they could and couldn't do outside the state. They could certainly contract with it and say, I promise you I will not be involved, and this is the nexus, I will not be involved with any Nevada gaming licensee in matters regarding gaming outside of Nevada's borders. So again, there could be a contractual provision allowing that without saying that they couldn't do something in a foreign jurisdiction, they couldn't do something with a Nevada licensee in a foreign jurisdiction. And of course, they could contractually agree to whatever they would be willing to do in order to resolve their Nevada matter.
Okay, but those contracts are basically voluntary. You don't have the authority to tell them what to do in another country.
Kirk Hendrick, again for the record, we don't have the authority to enforce what he may do, she may do in another jurisdiction, an entity may do in a foreign jurisdiction unless there is a Nevada nexus. And then if we contractually agree to it, then we at least have a contract that we could bring into court and say they are violating our stipulation, our contract.
Very good. Helps keep Nevada nice and squeaky clean.
Thank you.
All right, any other questions from members? I have one quick question about a portion of the bill that I don't think anybody else asked about. And unless I'm misunderstanding, I think at the end, you're repealing the current 463.169 in order to add the people who hold contests or tournaments to a longer list of operators in section 4, subsection 5 on page 5. And I've been flipping back and forth for a little while trying to figure out what the substantive change is then for people who are planning to conduct a tournament. And I think it'd be faster if you guys could just explain it to me.
Thank you, Chair Scheibel. Sebastian Ross for the record. What we're doing with that provision is instead of making the third party register with the board, the licensee is going to be responsible, but we would still have jurisdiction and have the ability to call the third party forward.
So would the licensee be required to inform you that the third party is going to conduct a tournament and provide like their name or contact information in advance?
Sebastian Ross for the record. If the board were to reach out to the licensee and inquire any information, the expectation would be for the licensee to have that information upon request.
Okay, I appreciate that. Any other questions? All right, we have asked all of our questions and you have answered them thoroughly. We really, really appreciate that. So at this time, we will close the presentation of the bill and we will move on to testimony in support of SB 46. We'll start with anybody wishing to testify in person, either in Las Vegas or Carson City. I don't see anybody coming down to the table to give support testimony in either location. I'll give you all just a minute, but I think we can move on to the phones, please. AVH, is there anybody on the phone to give support testimony on SB 46?
Thank you, Chair. The public lines are open and working. However, there are no callers to provide support testimony at this time.
All right, then. Let's go to opposition testimony on SB 46. I don't see anybody coming to make in-person opposition testimony in Clark County or Carson City. So we'll go to the phones for opposition testimony on SB 46.
Thank you. There are no callers to provide opposition testimony at this time.
Okay, we will take neutral testimony on SB 46. Come on down to the front table here whenever you are ready. And please try to limit your comments to about 2 minutes if you can.
Thank you, Chair Scheibel and committee members. Misty Grimmer representing the Nevada Resort Association. As Mr. Hendricks said, we've worked closely with the GCB staff on the provisions of this bill and initially had some concerns with the bill, but based on the testimony of the chair and the amendments that are before you, we are now neutral, since it is their intention to adopt regulations that will determine timelines for when the GCB must file a complaint for disciplinary action, file a claim for taxes and fees, etc. And when they are investigating whether to allow a person to terminate their licensure and how long after a person or entity is no longer licensed they are able to open an investigation on that person, a statute of limitations, essentially. Thank you.
Thank you so much. Do we have any other neutral testimony? It looks like we do have somebody in Las Vegas. Please go ahead, state your name for the record and spell it, and give us your testimony whenever you're ready.
Good afternoon, Chair Scheibel, committee members. For the record, Darren Dorsey, D-O-R-S-E-Y, from the Association of Gaming Equipment Manufacturers. We echo the comments from the Resort Association and would not want to reiterate those here. But we're here in the neutral position like them on SB 46 simply because we have some technical concerns about the bill as drafted. And I think the discussion amongst the committee kind of raised some of those and the chair as well. From at the outset, we understand why the board wants to have continuing jurisdiction or expand the ability of the board to not have to accept a surrender of a license until it completes an audit or an investigation of some alleged wrongdoing. Our concern, however, is that the bill as drafted, even with the amendment, is somewhat open-ended. It has no specific time limitations. We do understand that it is possible that different scenarios will require different time restrictions or maybe different statute of limitations. For example, if for a situation where a person or entity that has a license or other approval is alleged to have violated the Gaming Control Acts, the regulations, or some other laws, and that person leaves the industry so that they can try to avoid discipline, the board may only maybe need 6 months, 12 months to complete its investigation and file a disciplinary action. However, if a licensee attempts to surrender a gaming license or close an establishment and owes the state taxes, fees, that period may need to be longer for the board to protect the state and collect those taxes and fees. There could also be a bankruptcy, receivership, or other issues that make the matter take longer. So we'd realize it's not a one-size-fits-all solution. Like the Resort Association and the chair mentioned, we have been discussing these with the board, and we look forward to being able to address those in the commission regulations. But that's why we're here in the neutral position today.
Thank you so much for your testimony. I don't see anybody else coming up to testify in the neutral position in either in-person location, so we'll go to the phones, please, for any neutral testimony on SB 46.
Thank you, Chair. The public lines are open and working, but there are no callers to provide neutral testimony at this time.
All right, then that brings us to the conclusion of our hearing on SB 46. Unless the presenters have any closing remarks that you'd like to make, please come on down and give your remarks whenever you're ready.
Thank you, Chair Scheibel. I will be very brief. Kirk Hendrick for the record. I give you my personal guarantee and assurances that we will continue to work with all stakeholders to be sure that the language that we are proposing fits with the reality of how all of these matters should be handled by the Gaming Control Board. On behalf of the Game Control Board, myself, the other members, our 400 employees in the Nevada Game Commission, I thank you all for your time. We appreciate it, and we respect you and what you all do on behalf of the state of Nevada. Thank you.
Thank you. All right, I will close the hearing on SB 46. At this time, I think we need to retrieve our next presenter from another committee, so we'll go to a brief recess. Oh, he retrieved himself. We're back out of recess. And I will go ahead and open up the hearing on SB 125 and invite our colleague, Senator Steinbeck, down to the witness table to present this bill.
Thank you, Chair. Thank you to all of the members of the committee for hearing this bill today. For the record, I'm Senator John Steinbeck, representing Senate District 18. I'm pleased to present Senate Bill 125, which revises provisions relating to services provided to victims of crime. In 2021, in response to the Route 91 Harvest Festival shootings, the legislature passed Assembly Bill 481, which required the Nevada Division of Child and Family Services to designate a statewide center to provide assistance to victims of crime. And since that time, the Resiliency and Justice Center has been designated as a statewide Victims Assistance Center. Located in Las Vegas, the Resiliency and Justice Center is a multi-agency resource dedicated to healing and support in Nevada. Their commitment is to all survivors of crime, emergency responders, and those impacted by the Route 91 Harvest Festival, the University of Nevada, and the University of Nevada Las Vegas shootings. It is managed by Legal Aid Center of Southern Nevada, and their partner agencies include Clark County, Las Vegas Metropolitan Police Department, and the state of Nevada. The bill before you today, SB 125, is designed to ensure victims and survivors of violent crime have access to the resources provided by the Resiliency and Justice Center. The bill is intended to remove any barriers law enforcement has in sharing appropriate victim information with the center. This will allow more people to receive assistance in behavioral health, victim of crime compensation, legal assistance, and to utilize additional local, state, federal, and nonprofit resources. I would now like to allow Tyler Winkler, Supervising Attorney for the Resiliency and Justice Center, and Tanil Pereira, Director of the Resiliency and Justice Center, the opportunity to provide additional testimony.
Good afternoon, Committee Chairwoman Scheibel and other members of the committee. My name is Tanil Pereira, and I'm the Director of Legal Aid Center of Southern Nevada's Resiliency and Justice Center, which was previously known as the Vegas Strong Resiliency Center. Just for historical reference, because I know many of you are familiar with the awful events that brought the Resiliency Center into existence. On 1 October 2017, the country's largest mass shooting in modern U.S. history took place in our state. It left 58 dead in the immediate aftermath, and several others then followed in the years following. Clark County established the Resiliency Center as a place of healing and hope for all those impacted. Legal Aid Center of Southern Nevada provided legal services immediately following and staffed at the Resiliency Center because of Legal Aid's extensive knowledge serving victims and its long history of effective collaboration across organizations. In 2021, the designation of a statewide victim assistance center was established through NRS 217.096. Because of the Resiliency and Justice Center's expertise in victim services, its public-private collaborative model, and knowledge and experience responding to mass incidents, it was selected through a competitive process as Nevada's first statewide victim assistance center. One of the primary roles under this designation is the responsibility to work with victim service providers across the state to streamline processes, identify and remove barriers to services, and identify ways to fill in service gaps. The Resiliency Center works with first responder agencies, including law enforcement, physical and mental health service providers, other victim advocate organizations, judicial partners, and other organizations able to provide resources to help stabilize a victim's life and family, allowing them to move forward and heal. Wherever possible, the Resiliency Center looks for ways to navigate the system on behalf of victims so that they don't have to. Navigating the various agencies, service providers, and resources available can be challenging on someone's best day, let alone on their darkest. We also work to forge an easier path for the many other organizations assisting victims in our state and anyone that finds themselves alone on this path. That brings us to today, and SB 125. I would first like to thank Senator Steinbeck for his life's dedication to serving those that find themselves in dire circumstances and for bringing this bill forward. Next, I'll turn the time over to Tyler Winkler, our supervising attorney that works directly with our amazing victim advocates. Our advocates work on the front line of victim services every day. When they start to run into systemic roadblocks or service gaps, they turn to us for solutions. That is what SB 125 is, another step forward to remove systemic roadblocks to access victim services. Tyler?
Good afternoon, Committee Chair Scheibel and other members of the committee. For the record, my name is Tyler Winkler. That's Tylerwinkler. And I am the supervising attorney at Legal Aid Center of Southern Nevada's Resiliency and Justice Center, formerly the Vegas Strong Resiliency Center. I work with the Resiliency Center's advocates to help individuals impacted by trauma overcome complex challenges to long-term recovery. And in doing that, always prioritizing their safety, dignity, and well-being. A major component of this work is to ensure that those impacted by trauma are not alone in identifying and navigating these complex, disconnected systems. That is what SB 125 works to address. This bill adds a new subsection to NRS 217.096, clarifying that government entities, consistent with their internal policies, may, but are not required, to share victim information with the state-designated Victim Assistance Center for the sole purpose of providing them long-term support services. Furthermore, this bill makes it clear that the statewide Victim Assistance Center is strictly prohibited from disclosing any received information, and the confidential status of shared information remains unchanged. The permissive nature of this bill, combined with the explicit reference to federal law, ensures compliance with state privacy protections, as well as federal laws like the Victims of Crime Act and Violence Against Women Act. This bill is necessary because too often survivors are frequently redirected from one entity to another and are forced to repeatedly share their trauma stories with each new entity or agency they encounter. Understandably, this is re-traumatizing, alienating, and overwhelming. This not only impacts their safety and recovery, but can also discourage them from seeking the support they need and are entitled to in the first place. For example, a victim of domestic violence has immediate needs. They need to seek a protection order and emergency housing. They'll also need more long-term needs. Perhaps they have a child with the perpetrator and they're going to need family law services. The perpetrator was the primary breadwinner, so they need financial assistance or maybe even new job training. There are many different government entities and agencies that are going to have information that's going to assist that person move on and get these things done. They may be working with the statewide Victim Assistance Center and have given the center authorization to work with government entities to collect that information, but they're going to be told that they have to go themselves and personally request it. This bill will streamline and enhance that process so that way they don't have to go to each place individually. In doing this, it will empower victims and give them more control over their own next steps. Giving them timely access to vital information ensures their needs are prioritized, safety plans are developed, and services like legal advocacy and mental health support are delivered without delay. Ultimately, this bill strengthens victim support while upholding strict confidentiality protections and ensure that victims and their families receive the support they need in a way that respects their emotional well-being, minimizes additional harm, and fosters long-term resilience. I would like to thank you all for your time and attention to this very important matter, and I'm happy to answer any questions you might have regarding SB 125.
Thank you so much. Senators, I know we have a couple of questions. I will start with Senator Krasner.
Thank you, Chair. Thank you for your presentation. I think the law in this area is good the way it is, but I have some questions about these changes. So in Section 1, subsection 4, where you add language about a governmental entity sharing the confidential information of a victim. When someone becomes a victim, they do not lose or forfeit their right to privacy under the Fourth Amendment to the United States Constitution. Also, the new language you added in Section 1, subsection 6, you're now including governmental entities, including the government of the state, an agency of the government of the state, a political subdivision of the state, and an agency of a political subdivision of the state. Again, these are victims of crime. So my question is, do people need to opt in writing to get services, or does this bill propose to share victims' confidential information without their knowledge or consent?
Thank you very much, Senator Krasner. For the record, Tyler Winkler. So a big part of this bill is to ensure that each different entity, they're going to have their own consent and disclosure requirements. Sometimes it's going to be a written authorization. There are some federal laws, like the Violence Against Women Act, that requires informed consent, time-limited disclosure. And the reason that the statute is written the way it is, when that, again, it's permissive, it's not mandatory, it permits each government entity to ensure privacy protections at that level.
So that your answer was not reassuring to me, because what's happening here is the bill is proposing to share a victim's confidential information without their knowledge or consent. And I looked at what is an example of an agency of the state government: the Department of Motor Vehicles, the Department of Corrections, Department of Health. What is an example of a political subdivision of this state? The county health department, the public health department, a school district. Currently, criminals who are convicted of a crime lose some of their constitutional rights. But these are victims that we're talking about. Victims should not lose their constitutional right to privacy or have their confidential information shared under the guise that we're helping them. If they want services, they should have to opt in writing. Maybe they don't want services. Maybe they don't want to be on a list. They're a victim. That's all. Thank you.
Thank you, Senator Scheibo. Senator Krasner, thank you for your question and your comments and your concern. And
if you could state your name for the record.
Sorry, Tanel Pereira. This is not intended to not require the victim's permission. All of the current confidentiality laws that are in place cannot just be ignored. They're still in place, and I absolutely agree with you. They are still entitled to their constitutional rights. There's nothing about this is intended to take away their rights in any way. This is meant to break down barriers where we have agencies when a victim has said, "Can you please get this from this organization?" And they will even put it in writing for us. We will send that entity or organization this in writing, and then they will still say, "We're not sending it. You have to send them here." And so what happens is they end up going in circles. So I agree with you, and that is not what this is intended to do.
And maybe I could clarify a little bit, because I did have a conversation with you, Senator Steinbeck, beforehand, and I don't want to malign any of our nonprofits in Southern Nevada, because I know the really hard work that they do. But it sounded to me like you were encountering situations where someone comes in, they're a victim, they say, "I would like to receive counseling," and the Resiliency Center says, "Great, we have a counselor. Let me connect you with them," and then that counselor wants to re-refer them but says, "Oh, but I can't share their information." And so you're running into a problem where a victim actually wants to receive services, but agencies aren't talking to each other. One agency might have a phone number for someone who we know is a victim of a crime, and we want to contact that person because they are eligible for services, but one agency is nervous to hand that phone number over to the Resiliency and Justice Center, and so there's no way to contact that victim and let them know, "Oh, the counseling that you wanted is now available, but maybe you came in person, didn't leave a phone number, and now the agency who originally referred them won't provide you with their phone number." Is that the kind of thing that you're seeing happen?
It could be partly that circumstance, or it could be a circumstance where they don't want to go around and navigate, and they'll tell us, "Yes, you have our permission to reach out to these organizations that I've already worked with," right? So that we can centralize their services, and they don't have to go around and do it. And a lot of times it's like collecting documents that they need. for the Nevada Victims of Crime program. And now we have to tell them, sorry, they won't give it to us. I have to send you out to get it. This is permissive, and that allows that agency to then give that to us. And we require them to actually sign a release so that we can go and get those. We are in no way looking to go around the victims' rights and their confidentiality.
Okay, thank you. It looks like Senator Krasner has a follow-up.
Thank you, Chair. I appreciate that. And I appreciate what you're saying, too. I would just feel a lot more comfortable if the confidential information of victims was only shared if the victim opted in writing that they wanted your help and they were okay with having their confidential information shared with all of these entities. I would really appreciate if you could just put that amendment in there. I'd feel a lot more comfortable just as an advocate for our victims. Thank you.
Okay, I think Senator Wynn has a question as well.
More of a comment. I just want to just commend you all. Like, the work that you are doing at the Resiliency Center is just incredible. And the way I take this bill is there are very few organizations that have been able to go out and really protect victims on such a large scale. And it's unfortunate that it arose out of the events of October 1, but to see how we have been able, or your organization has honestly been able to, rise from this tragedy to help other victims in other circumstances is just an incredible vision that you have from your director. And it is no more apparent than in bills like this where you are trying to. So thank you, Senator Steinbeck, for bringing this bill to further alleviate the barriers that victims have when they are trying to seek services, further allowing victims to receive those services without being further victimized by having to relive that trauma over and over and over again as they go from one service provider to another. So I really appreciate this bill. Thank you.
Thank you, and I think Vice Chair Flores also had a question.
Thank you, Madam Chair, and thank you for the presentation. I know in government affairs, after 1 October, we had multiple conversations, different bills, unrelated, but I remember engaging in conversations where we realized that agencies weren't communicating as effectively as we wish it could have. Getting folk some of their personal belongings was a nightmare. Connecting family members was an absolute nightmare. Individuals who were volunteering and we were trying to keep them coordinated and sharing that information was an absolute nightmare. Moving resources. I remember trying to get funds and certain things to move between agencies. Federal, state monies moving around was a nightmare. And I think 1 October was a lesson to us because we had to start doing a lot of changes to the NRS to ensure that hopefully we never have a tragedy like that again, but if we do, that we are better equipped to share information. And if I could, because I think some of the stuff on my end, I just didn't understand that at times maybe agencies weren't cooperating or weren't being as helpful as they could have. Could you walk us through that? I would assume that Senator Krasner's concerns of them wanting the help is there. Victims have signed the releases, you have the release, but you're going to certain agencies and maybe even the release alone is still not working. Could you maybe just walk us a little bit through that, where they want the help and they're just not getting it?
For the record, this is Tyler Winkler. So thank you very much, Senator Flores, for the opportunity to walk through that. Very common scenario is we will have someone seeking victim compensation. So as part of that, there's a few documents you need to get together. The most important one is you need a police report. And so we'll have the person in front of us. They want to apply for victim compensation. We're gonna fill out all that paperwork and submit it. But in order to get that police report, even though we have an authorization signed, it's compliant with federal laws about it being time limited, revocable. We'll try to send that off to a law enforcement agency, and usually it's out of an abundance of caution. They're like, we don't know if we can give this to you, or more likely they won't say anything in case they will unintentionally breach this confidentiality of a person, and they'll say, anyone who needs a police report, they need to come down here and get it themselves. So you can see the delay there. We have the person there ready to go. Maybe they need medical bills paid, or we have a mental health provider ready to go, but they need to pay them through the victim compensation program. Same kind of issue with seeking a protection order. Again, if you have a police report or some kind of documentation from a law enforcement agency, that's going to go a long way to ensure that that person gets a protection order, but they're going to have to go to a couple different agencies to try to piece all that together currently as it stands.
And I know anecdotally the attorneys in the room will tell you that they've had assigned a release, send it out to a particular agency, and because it's not in their template, it's not in the format they wanted it, even though they know it's a perfectly valid legal document, you know, they make attorneys jump through some hoops there sometimes, so understood. I think everybody just wants to make sure that we're obviously protecting humans, and of course that, but we're all on the same team here, so absolutely appreciate the work you do. Thank you.
Other questions? Senator Ellison.
Thank you. One of the questions I've got, it looks like there's several of these agencies that's involved. I keep forgetting to move it because of this thing. There's so many agencies involved in this, it looks like, and some of the ones you read about. How did the funds come to pay for all these different agencies they might have to go to see? Is this all voluntary, or is this what? It come from federal government, state government? According to this, it's zero in finance, 0, 0. So could you explain that? Maybe that'd help all of us.
Tanil Pereira for the record. So the funding sources come from all over. And I think that's probably part of the reason that our victim services is so piecemeal. Because when victims' rights really started to be established back in the Reagan era, there were 2 acts that allowed for funding for victim services on the federal side. It was VAWA, which is Victim Assistance for Women, and the other one for VOCA. Generally, it's been focused on women and sexual assault victims. So those came through, but it only covered those 2 pieces. So then what you had crop up were a lot of like local nonprofits or your local governments would provide funding to try and cover some of the other gaps, the other individuals that were victimized that weren't covered under the other funding. So what we have currently is this piecemeal victim services structure, and it has left big gaps, and it has left organizations working in silos. And then we have the victims come in, and they're forced to navigate this system. I hope that answers your question, Senator.
All right. Any further questions?
Madam Chair, can I comment on a couple of things there, please?
Sorry, there's no question on the floor. I'm just kidding. Yes, please go ahead.
Thank you, ma'am. Thank you for your comments and really appreciate it. What I wanted to just really emphasize here is that following 1 October, we had, during the 1 October, we had a monster that just wanted to inflict pain, right? I mean, we never found any other motive. That was all. That was all we found. And from that point, our mission moving forward for as long as it took was just to alleviate suffering, right? And so when you have people come in and they need that assistance, and we've seen it certainly on a smaller scale many times, not a smaller scale for them, but a smaller scale for our community. And you just want to help them. You want to try to take away any type of burden that they might have all the way across the board, any services that you might provide. And so when you have the funding for those services, you have the people for those services, you have the ability to provide them, you have everything but the authorization for some of this. It's very disheartening for them, and they don't understand why government can't get on the same page and why we can't get on the same page with some of our partners. And so that's really the reason why we've brought this together. We found a pinch point, right? where are all of our different pinch points? And like Senator Flores said, we came right after that incident. We changed 10 different laws following that incident throughout the state, but we still found pinch points moving forward. And so this is the biggest one that we have right now. This and a bill that was provided in the assembly earlier today. So that's what we're looking to work through. You'll see in the it simply says that they may provide. There's not a shall here, right? So it is there for the agency to know that by state law they may provide that information. The authority to do that still lays with the victim where it should, or the survivor. Thank you.
Thank you so much. I think this was an excellent presentation, and I echo my colleagues' sentiments of appreciation for the work that you all do, and appreciate you taking the time to come here today and explain a little bit more of that to us, as well as presenting SB 125, which I think will be a step in the right direction to ensure that we have those comprehensive wraparound services. And with that, we will close out the presentation portion of this bill hearing and move to testimony. We'll start with testimony in support of SB 125. Anybody wishing to testify in support in either Las Vegas or Carson City is invited down to the front to do so now. Go ahead.
Good afternoon, Chair and members of the committee. My name is Riley Svensson, RYLEY SVENDSEN, and I am the Policy Specialist with the Nevada Coalition to End Domestic and Sexual Violence. I want to thank you all for your thoughtful questions to ensure victim survivors' constitutional rights are being protected. We are here today to support SB 125 because we believe that this bill will help to break down barriers for victim survivors to receive the services that they need. Coordinated communication and sharing of information at the victim's request is a trauma-informed approach, and this bill will reduce barriers and help to simplify the process of navigating care and support after violent crimes. Thank you.
Good afternoon. My name is Misty Richardson. I'm with Clark County Office of Emergency Management. Thank you. I wanted to express my wholehearted support in SB 125. Victims who have experienced a traumatic situation are often forced to regurgitate their experiences, which is diminishing and re-traumatizing as they go from one agency to the next in order to seek services. The Resiliency Center Advocates' sole mission is to remove the re-traumatization of this bifurcated victim service system. We appreciate your consideration of this bill, and I thank you again.
Good afternoon, Chair and Committee. My name is Billy Samuels. I am the Fire Chief for Clark County Fire and also the Emergency Manager for Clark County. When we do have these horrific events, we do obviously set up the Multi-Agency Coordination Center. The Vegas Strong Resiliency and Justice Center is part of those collaborations. When you do have these patients and victims that are affected by these events, going back and forth from place to place and retelling those stories is horrible. And I know that firsthand because we've experienced it with 1 October. 1 October could have been way worse. We lost a lot of people. A lot of people were injured. 800 injured and 58 plus 2 deceased. It could have been worse. This is a trial for us to actually get better and have a program in place so when this does occur, or if it occurs, we will be prepared. I am 100% in support of this bill. Thank you.
Thank you so much. I don't see anybody else coming down to give support testimony in Carson City, so we will go to Las Vegas, where I don't see anybody in the room, so we'll go to the phones for support testimony on SB 125.
Thank you, Chair. The public lines are open and working, but there are no callers to provide support testimony at this time.
All right, then we'll move to testimony in opposition of SB 125. I don't see anybody to make opposition testimony in Carson City or Las Vegas. So we'll go to the phones for opposition testimony on SB 125.
Thank you, Chair. There are no callers to provide opposition testimony at this time.
All right, we will go to neutral testimony, and I also do not see anybody coming down to the front in Carson City or Las Vegas to give neutral testimony. So we'll just be thorough and check the phones and see if there's anybody to give neutral testimony on SB 125.
There are no callers to provide neutral testimony at this time.
All right, then that brings us to the conclusion of testimony. Unless the presenters have any closing remarks, I will close the hearing on Bill SB 125. Thank you so much for being here. And that brings us to the last item on our agenda, public comment. Anybody wishing to give public comment is invited to do so now in person in Carson City or Las Vegas. I don't see anybody coming down to the front. So one last time, let's check the phones and see if there's anybody here to give public comment.
Thank you, Chair. There are no callers to provide public comment at this time.
All right, then that brings us to the conclusion of our meeting today. We will not be meeting tomorrow. Our next meeting will be on Monday, March 3rd. Also, I wanted to let the committee and anybody else know that I do anticipate meeting on Tuesday, March 4th. We're just working on that agenda still. And with that, we are adjourned.